there's a lot of crazy claims that your spouse can make related to the title to these homes if your spouse isn't on the title to these homes. And so that's something to consider. I know you might think if you're married and your spouse signed a quitclaim deed, that he or she is certainly shouldn't be entitled to any community property interest in, maybe your luxury home or rental properties or something like that. But unfortunately, in California, there is a possibility that your spouse might still be entitled to an interest in these real estate assets, even if his or her name is not on title. If she or he can show that there was undue influence somehow involved in you having your spouse sign a quitclaim deed. So it's not necessarily so cut and dry as you might think. It's more nuanced. And you might think just because your spouse's name isn't on the title to these deeds that, oh, it's a no-brainer, and no, she or he doesn't get any interest in these properties. But I would strongly suggest you consult with a family law attorney, because what we wouldn't want you to do is to sabotage your case and for you to have unrealistic expectations and draw a line in the sand and say no, and then have to pay a bunch of legal fees, in order to try to go after some argument that doesn't really hold weight in court. We'd want to really carefully vet whatever it is that you think you are entitled to. We want to really carefully review whatever deeds you have related to the property and the chain of circumstances that occurred in order to make sure that your rights are secured and that your spouse doesn't have any claims of undue influence or something like that related to the signing of the quitclaim deed.